Good morning, Carolyn. Oh, okay. What about now? Hello, hello.
Morning, Judge. No. There you
There.
go.
Okay,
Can you hear me then?
yes.
Okay.
Okay, so I made you a co-host, Donna, so you can take off whenever you want.
Okay.
Thanks. Before we go on the record, does anybody want to talk about anything before we go on the record? Okay. And wait just another minute.
Madam Hearing Examiner, if I may,
Yeah.
am I coming through clear today?
Yes, you sound better.
Okay, great. Second thing, Mr. Tupler's up next, I understand, and I'll be getting staff exhibits 5, 6, and 7 into the record, hopefully. And as you recall, Ms. Eschberger, who left the commission, her testimony is marked as staff exhibit 4, and I'll be bringing that in with Ms. Dashno after Mr. Tupler's done today. Is that okay with you?
Yes, it is. Thank you.
Thank you.
David, are you ready to go on the record?
Yes, Your Honor.
Okay, let's go on the record. Mr. Bagatko, you may call your next witness.
Madam Hearing Examiner, I would call Mark A. Tupler to the stand.
Mr. Tupler, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Tupler. How are you?
Hi, very well.
All right. Did you prepare 3 testimonies in this case?
I did.
And I believe you probably have those in front of you. Your direct testimony, supplemental direct testimony, and second supplemental direct testimony. You have those handy, sir?
I do.
All right, well, let's start with the direct testimony, which has been provisionally marked as Staff Exhibit 5. You do have a copy of that in front of you, I understand.
Exhibit 5, I do.
All right, looking at Staff Exhibit 5, is that a complete and accurate copy of the direct testimony you filed in this case on October?
Yes, it is.
2020?
Yes, it is.
Thank you. You don't have any changes or corrections to make to that direct testimony, do you, sir?
None noted.
Thank you very much for that. And if you were asked today the same questions that are posed in your direct testimony at this public hearing, would your answers to those questions still be the same as the answers reflected in your direct testimony marked as Staff Exhibit 5?
Yes, they would.
Well, with that, Madam Hearing Examiner, I would move for admission into evidence the direct testimony of Mark A. Tupler, which has been marked as Staff Exhibit 5.
Is there any objection? Staff Exhibit 5 is admitted.
All right, now, Mr. Tupler, if you'll direct your attention to your supplemental direct testimony, which has been provisionally marked as Staff Exhibit 6. Are you there, sir?
I am there.
Thank you for that. And if you'll take a moment to look through that, is that a complete and accurate copy of the supplemental direct testimony you filed in this case on October 27th, 2020?
Yes, it is.
And again, Mr. Tupler, I trust that you don't have any corrections or changes to make to your supplemental direct testimony, do you?
I don't.
And Mr. Tupler, if you were asked the same questions today as the ones that are contained in your supplemental direct testimony, would your answers to those questions change, or would they be the same as what is reflected in your supplemental direct testimony?
They would be the same.
Thank you for that. Well, with that, Madam Hearing Examiner, I would move for admission into evidence the supplemental direct testimony of Mark A. Tupler, which has been marked as Staff Exhibit 6.
Okay. Is there any objection? Staff Exhibit 6 is admitted.
Finally, Mr. Tupler, we turn to the second supplemental direct testimony, which was filed on December 17th, 2020. Do you see that, sir?
I am there, yes.
Fantastic. And that second supplemental direct testimony of yours has been provisionally marked as Staff Exhibit 7. Do you see that?
I do.
Take a moment to flip through your second supplemental direct testimony that you have in front of you. Make sure that it is a complete and accurate copy of what you caused to be filed in this case on December 17th, 2020.
Yes, it is.
Thank you for that, Mr. Tupler. Regarding changes, corrections, do you have any to make to the second supplemental direct testimony?
None.
Thank you. Finally, Mr. Coupler, if you were asked today the same questions posed to you in your second supplemental direct testimony, would your answers still be the same as those reflected in your second supplemental direct testimony?
Yes.
Well, with that, Madam Hearing Examiner, I'd move for admission into evidence the second supplemental direct testimony of Mark A. Tupler, which is marked as Staff Exhibit 7.
Is there any objection? Staff Exhibit 7 is admitted.
And with that, Madam Hearing Examiner, I tender Mr. Tupler for cross-examination by the parties. Thank you.
Okay, Mr. Zadowski, you're up and you have 45 minutes.
Thank you, Madam Hearing Examiner. Good morning, Mr. Tupler. How are you today?
Hi, very well.
Let's start in the second supplemental testimony that we were just discussing that was marked Exhibit 7. On page 5 of that second supplemental testimony, you updated your ROE recommendation from 9.0% to 9.3%. Is that correct?
Yes, sir.
And your range of reasonableness for the case for your recommendation of 9.0 to 9.55, that stayed the same following the update to your actual recommendation. Is that correct?
Yes.
If we flip, sir, to your direct testimony on page 27,
Direct, page 27.
and I'm going to be looking specifically between lines 10 and 13 or so, 13 or 14. You're observing that the average authorized ROE for electric utilities, according to Regulatory Research Associates, in the first half of 2020 was 9.55%. Is that right?
Yes.
Is it your understanding, sir, that RRA's reported 9.55% average authorized ROE in the first half of 2020 includes ROEs for all electric utilities, including distribution-only utilities?
I believe that is the case, yes.
And your recommendation of 9.30% is below that value, correct?
Yes.
Mr. Tupler, do you agree with the generally accepted financial principle of risk and return, which observes that investors require a higher return to compensate them for taking on greater risk?
I do.
Is it your opinion that EPE is less risky than other electric utilities?
I would say the risks are commensurate with the other companies in the peer group that I selected.
Okay. So Mr. Tupler, in your direct testimony, there were 3 exhibits. Could you flip, sir, to exhibit MAT-2? And in my version, this is an excerpt from a spreadsheet, and in my version, it's kind of flipped on its side, so you might have to rotate it if you have a PDF.
Agreed. So the exhibit 2 that I show in my direct testimony is an incomplete version. I believe the entire spreadsheet was submitted subsequent to this. So the MAT2 in exhibit 5 may not be a complete spreadsheet.
Okay. Can you look though at the line, and again, you'll have to rotate it to look at it, but can you look at the line just called S&P credit rating? Do you have that, that vertical
Let's see
line on your copy?
I'm gonna flip it around here. Okay, bear with me. This is coming up slowly but surely.
No rush, sir.
So I can't seem to flip it properly. So I'm going to try a different approach here. Okay, I've got the exhibit in front of me properly.
Okay, and you do see that line S&P credit rating?
I do.
And there are 7 ratings there.
Correct.
And so despite the fact that we can't see all of the information that would be on the spreadsheet, do you understand those 7 ratings to be the 7 ratings of the proxy group that you selected?
Yes.
And so if I'm reading this correct, 3 of the proxy companies are BBB plus, 3 are BBB, and 1 is BBB minus, I guess. Is that what you'd say?
I see that. Yes.
So EPE's credit rating is BBB, is that correct?
I believe that to be the case. Yes.
And so it falls kind of in the middle of the range of companies that you've selected?
Agreed.
Okay. And so based on this information and where EPE falls in here, do you conclude that EPE is less risky than other electric utilities?
Well, again, I would say that their risk level is comparable to the peer group that I selected. So not more, not less, but somewhere within that range of comparable credit risk.
Okay. So Mr. Tupler, thank you for that. If we could turn back to page 19 of your direct testimony. And I'm going to be looking here between lines 21 and 24. Here in your testimony, you're naming the 7 proxy group companies. Is that right?
Yes, I see them.
And I guess they are Alette Incorporated, Avista Corporation, Northwestern Corporation, Otter Tail Corporation, Portland General Electric Company, Hawaiian Electric Industries, and PNM. Did I get them all?
Yes, you did.
Okay. And on page, if we flip back a page and we kind of think about the content of pages 18 and 19 together, it's my understanding that what you're doing here on pages 18 and 19 and the top of page 19 is that you're describing the screening criteria that you applied to develop your proxy group. Is that the purpose of this part of your testimony?
Yes, it is.
And so on page 18, at lines 23 to 25, you seem to be saying that your proxy companies have to have a market capitalization between $1 billion and $5 billion. And the purpose of that is to ensure capture of relevant small to middle market utility companies. Is that correct?
Yes, it is.
So did you apply that particular screening criterion because EPE is a small utility?
Yes.
So in your opinion, is it reasonable to develop a proxy group that's relatively comparable in size to EPE to estimate the cost of equity?
Yes.
And so do you agree that size is a relevant risk factor when estimating the cost of equity?
In my experience, it's a very important factor.
Did you consider the company's nuclear generation as a risk factor?
I did, in a very minor way. It wasn't as important a factor to me as the criteria that I set out on page 18 and 19.
But it was something that you considered.
Correct.
And do you think that nuclear plant ownership increases the risk to a utility company if all else is held equal?
It probably does.
Do you know how many companies in your proxy group own nuclear assets?
That was the limiting factor in that aspect of my analysis. I did not have the opportunity to investigate the other nuclear capacity of the other companies.
Okay. If I represent to you that PNM is the only company in your proxy group that has nuclear assets, would you have any reason to disagree with that?
No.
Are you aware that PNM's ownership in Palo Verde is less than 10% when compared to EPE's ownership share of 15.8%?
I was not aware of that.
Is it appropriate to say that EPE has more risk in your proxy group due to its exposure to nuclear power?
Theoretically, I'd say yes. I don't know how to quantify that. So again, it didn't impact my much in my analysis of the risk.
Okay, but with that qualification, is it your opinion that EPE's smaller size and nuclear exposure make it more risky than the companies in your proxy group if all else is equal?
Slightly, yes.
I still don't have this question. I've probably only got 6 or 7 more minutes. Okay. Let's move on to a different topic. Can we turn, sir, to page 35 of your direct testimony?
35. I'm there.
Okay. And at page 35, and I'm going to try to pull a line reference out here for you. Looking at lines 1 and 2, you're noting that you adjusted the value line growth rate for the Avista Corporation because it was extremely low. Is that correct?
Yes.
And do you recall what the original growth rate published by Value Line was for Avista?
I do.
And what was that, sir?
So according to my spreadsheet, which is the entirety of MAT, Exhibit MAT2, the growth rate from Value Line was 1%.
For Avista.
Correct.
And what did you adjust it to, sir?
I believe it was 3.2, if I'm not mistaken. Let me get back to my testimony. So we're talking about a Vista Corporation.
Yes, sir.
I may, Mr. Tupler, are you looking for what you talked about on page 35 of your direct testimony up there through lines 1 through 8?
Yes. So I'm going to stick with what's in my testimony, which says that the original projected growth rate from value line was 2%, and I projected it to 3.2%.
Okay, thank you, sir. And did you adjust any growth rates for any other companies in your proxy group?
I believe I did.
Do you recall whether or not you changed the growth rate for Northwestern Corporation?
I did.
Do you know what the initial growth rate, the initial value line growth rate was for Northwestern Corporation?
Yes, I do.
And what was that, sir?
2.5 is what value line reported originally.
And what did you adjust it to, sir?
I adjusted it to a nominal 3.5%.
And did you adjust the growth rate for Otter Tail Corporation, sir?
I did.
Do you recall what the initial growth rate was for Otter Tail Corporation?
Value line's original growth rate was 5%.
And what did you adjust it to, sir?
7%.
So is it your opinion that the original growth rates for Avista, Northwestern, and Otter Tail were unreasonably low?
Yes,
And was that the reason for the adjustment?
correct.
Mr. Tupler, if we turn to page 36, which is just the next page of your direct testimony,
36, I'm there.
and if we look between lines 17 and 19, you're noting that the CAPM model is considered to be the most widely accepted financial method for estimating the cost of equity in both the financial and academic fields. Is that your testimony there?
Yes,
Does that remain your testimony today?
it is.
I'm sorry,
definitely the most-
I'm sorry, Mr. Tupler, let me rephrase that. I don't want to ask if it remains your testimony. What I want to ask is whether or not it remains your position today or your opinion today.
It is the most widely accepted financial tool.
Thank you. If we turn, Mr. Tupler, to your supplemental testimony, which we also will call your first supplemental testimony, which is Exhibit 6.
I'm there.
And if we look at page 3, kind of between lines 15 and 20, my reading of it looks like you're updating your DCF analysis to reflect average stock prices over a 30-day period. And the 30-day period that you're using is November 18th, 2019 to December 31st, 2019. Is that correct?
Yes, sir.
And I should clarify, I don't mean a 30-day period. What I mean is 30 trading days. Is that
Right.
is that more accurate if I say it that way?
Exactly. They are trading days, not calendar days.
Okay. And stock prices have varied widely since December 31st, 2019. Is that correct?
During that time frame, or are you talking to the current period today?
To the current period today. There's been change in the stock market and stock prices since December 31st, 2019. Is that right?
Generally, I can presume that, but without seeing the data, I don't know.
Okay. That's fair. And the stock prices, you've provided an analysis of the stock prices that we were just discussing in table MAT1S, correct?
I see it, yes.
Okay. Mr. Tepler, if we turn again to your direct testimony on page 10, we're discussing LTD cost, correct? Between lines 8 and 11?
8 and 11,
Long-term debt costs?
yes. I see it.
So, Mr. Tupler, do you know what a make whole provision is?
Yes, I do.
Make hold.
I'm sorry, make whole, WHOLE. Can you explain what it is, Mr. Tupler, please?
Sure. My understanding of it is it's a term or a condition in a bond indenture that says in the event the bond is called or otherwise redeemed, the investors in that bond will be paid a premium in order to break the terms, which usually, of course, is going to add cost to the redemption of the bond to make them whole, which is in the question.
Okay. And are you aware that make whole provisions are common in debt markets?
I do.
And are you aware that EPE's debt is subject to make whole provisions?
At the time of this testimony, I wasn't aware of that. However, subject to interrogatories that were sent to EPE after this testimony, and I believe it was addressed in some of my supplemental testimony, I was made aware of that.
Okay. And so with the understanding that EPE has make whole provisions in its debt, if the company refinanced some of its long-term debt, the make whole provisions would result in no economic benefit to EPE and its customers. Is that correct?
I agree.
Okay.
You said no economic benefit.
Yes, Mr. Lee.
I apologize, you cut out there for a second.
It's no problem, sir. And Madam Hearing Examiner, that's all the questions I have at this point. Thank you.
Ms. Stevens, you have 10 minutes.
Thank you, Madam Hearing Examiner, and good morning, Mr. Tupler. Fortunately, I think Mr. Sadowski just asked most of the questions I have about your cost of equity analysis. So I'm going to turn to the oft-forgotten subject of capital structure. Okay?
Okay. Yes, sure.
And starting with we're in your direct testimony, staff exhibit 5, at page 5, 20 lines 15 to 16.
I'm sorry. Which exhibit,
Direct.
please?
Direct
I'm
number
there.
5.
Which page of his direct testimony?
Page 20, the discussion of capital structure begins.
Okay, I'm off a little bit here. Let me get to 20. I'm there.
And on page 20, lines 15 through 16, you testify that staff acknowledges and concurs with the company's proposed cap structure, right?
Yes.
And then if you turn to page 21, lines 12 through 14, you quote Mr. Hershey's testimony for EPE, which I believe was adopted by Ms. Budka, that says that that the requested 51% equity ratio is, and then in quotations, required to ensure EPE maintains investment grade bond ratings. Now, is that the company's testimony or yours?
Well, it looks like I've sourced it there, so I believe it to be Hershey's testimony.
Mm-hmm. And do you believe that EPE will lose its investment grade bond rating if the PRC does not approve a capital structure with 51% equity?
I'm sorry, Ms. Stevens. Can I have that question again?
Yeah. Do you yourself believe that the company will be downrated beneath investment grade if this commission doesn't approve a capital structure that includes 51% equity?
Well, in my experience, I would say that an increase in debt is a risk to a company and thus could be downgraded. The extent or the magnitude of that downgrade, I can't calculate. However, in my experience, an increase in debt is going to decrease the credit rating of a company.
Is there a one-to-one relationship? I mean, when you increase debt, do you automatically get a credit rating downgrade?
No, it's not one-to-one. I would tell you, in my experience with all of the major credit reporting credit rating entities, they have proprietary recipes for what's going to upgrade or downgrade a particular company. It's their own personal black box that makes them different from the other providers of this type of information. In my experience, it is not one-to-one, but generally, like I mentioned, an increase in debt is going to decrease their credit rating.
And Mr. Tupler, are you aware that EPE currently, or at the end of the test period, EPE's capital structure was approximately 49% equity and 51% debt?
I did understand that, yes.
And it was not until the capital infusion by IIF in September of this year that the requested 51% level was reached. Is that your understanding?
It is.
So when you talk about an increase in debt, as you just did, is describing how the rating agencies work, do you perceive the current situation, EPE's request in this case, as involving an increase in debt or a change from the status quo?
Well, I would say that with the equity injection, it's just a mathematical formula that will change the debt percentage. Not an increase in debt, but a decrease in the percentage because of the equity injection.
And to your knowledge, has EPE been evaluated, I don't know what the right terminology is, you do, by the rating agencies since that equity infusion occurred?
You know, I've looked, I haven't found, so I don't know.
And if we could turn to page 24 of your testimony. If I can turn to page 24.
Okay, I'm getting there. 24, I'm there.
On lines 17 through actually 24, carrying over to the next page, the question at the bottom of page 24. The question is asked, should the commission be concerned about how EPE finances its rate-based investment? And your answer begins, yes, as the capital structure greatly affects prices paid by ratepayers. And then on page 25, your final conclusion in this section on capital structure is that staff's lines 9 to 10, staff's basis for the capital structure recommendation is the status quo as it appears adequate and at no unnecessary cost to ratepayers. So my question to you, Mr. Tupler, is this at no unnecessary cost to ratepayers phrase, did you evaluate the additional cost to ratepayers of moving from the 49% equity ratio at the end of the base period to the 51% that the company is asking for now? In dollar terms.
Okay, so I'm not sure I understand that question. Could I have it again, please?
Yeah, given this testimony here, and specifically the phrase at no unnecessary cost to ratepayers, did you evaluate what the capital, what cost to ratepayers would arise through this case by going from the previous and actual test year 49% equity ratio to the requested and supported by you 51%?
I see. Yes, I did.
And what number did you determine that to be, in just in dollar terms, in the cost of service?
Well, I was speaking costs generally being unnecessary or necessary. So I don't have a dollar amount with this, but it's a conceptual capital structure principle is what my thought process was there.
And you do understand on a conceptual level, you do understand that ratepayers end up paying, because the cost of equity is almost always, virtually always higher than the cost of debt. The more equity in the capital structure, the more that ratepayers will end up paying, correct?
I do understand that. However, there is a strength that's added to the company with an equity injection. So in my opinion, that is a necessary cost, not an unnecessary cost.
And under what circumstances is it necessary? What are your criteria for necessary?
Equity injections almost always strengthen a company's balance sheet.
Do you understand that if a company decided, a company, and now EPE is essentially is part of a holding company, if a company or its holding company injects so much equity that they're up to 60%, would you consider that to be reasonable and necessary? It would strengthen the.
Well, a jump that big is material. There's no question about that. It might be unnecessary to have that much equity in the company. Debt is one of the biggest factors in my analysis here, because debt has to be supported by cash flow. Too much debt leads a company down the wrong path. Not enough debt doesn't give them the leverage they need to operate successfully and earn a profit. So to answer your question, a jump into 60% equity would strengthen the company, but it might strengthen it to an unnecessary level.
And
Ms. Stevens, your time is up.
Thank you.
Mr. Herman, you have 5 minutes.
Thank you, Madam Examiner. Good morning, Mr. Tupler.
Good morning, Mr. Herman.
How are you doing today?
So far, so good.
You were asked about effects on credit ratings by Mr. Zadofsky. Do you remember that?
I do.
And you mentioned that you weren't entirely certain how the rating agencies got their black box results, correct?
That's been my experience, yes.
Do you know what other factors might be considered above capital structure?
Well, I've listened to the testimony of other ROE witnesses, and they've all hit it right on the head. There is a giant recipe that these big credit rating firms utilize. The most important factor in analyzing a debt capacity or a debt, what is the proper term? A debt rating, I guess, is cash flow and earnings. Beyond that, there are potentially tens, maybe hundreds of other factors that might be considered in that, if we can call it an algorithm, because that's what they would probably call it. In my history, I've spoken to many credit reporting agency analysts, and they'll give me all the usual suspects like earnings and cash flow coverage and capital structure, debt to equity. There's a number of very standardized measurements, but then they always have their proprietary measurements, and those are going to be their house secrets, if you will. And I don't think many people know what those are.
Would you also include the debt coverage ratio in those factors?
Absolutely.
So you don't have any idea of what those agencies use as far as ranking whether they would prefer free cash flow or debt coverage ratio over capital structure, do you?
Not for utility companies, no.
Okay, that's all the questions I had. Thank you, Mr. Tupler.
Yes.
Mr. Bagaco, I allocated 5 minutes for redirect if you have any.
Yes, I do. Thank you, Madam Hearing Examiner. Mr. Tupler, do you remember being asked a question about CAP-M? You hear me, Mr. Tupler?
Yeah, I hear you. About CAP-M, I'm not sure if we addressed that. Was that today?
Yes. Do you remember discussing CAP-M in terms of it being a most widely accepted financial tool?
Yes, I do.
Why is that? What do you know about CAP-M that puts it in that position of apparent preeminence?
So I've been in the investment business one way or another for 25 years, and I've never seen it hit the mark. It is a theoretical, academic calculation from my perspective. I've analyzed it inside and out, and I can't seem to see it reconcile to what actually happens in the market.
But is it still a useful tool in what we do here at the Commission?
I believe it's one of the tools that we have, but it's not a major tool from my perspective.
Thank you for that. And then concerning your recommended ROE of 9.3%, if you'll re-educate us, why did you come up to 9.3% instead of your initial 9.0%?
I see. So at the time this testimony was due, I had some questions that were then produced as interrogatories to the company. I hadn't received those responses back yet, so I used the 9.0% as a placeholder for me until I got those answers from the company.
And so after that, you came up to 9.3% by virtue of that new information?
Yes, sir.
Do you still maintain that your recommended ROE of 9.3% is fair, just, and reasonable?
I do.
Thank you for that. And do you recall the questions that were asked of you by counsel for EPE this morning?
Yes.
And do you remember counsel was tooling through your direct testimony and some of your profile testimony, asking certain questions about the basis for your recommendation? Do you recall that?
I do.
Why do you think EPE was asking you those kinds of questions?
Maybe to understand the methodology that I used in my analysis of the peer group. which was a major factor in me coming up with my number.
You think EPE wants an ROE above your recommended 9.3%?
Well, based on the testimony that I've read from the company, I'm confident they do.
And why would it be wrong for an ROE to be awarded in this case above your 9.3% recommended position?
Well, part of my duty to balance the public interest is to look to the benefit and detriment of decisions to the ratepayers and to the shareholders. An ROE that is too high is detrimental to the ratepayer, and maybe more importantly, or I'm going to say equally as importantly, an ROE too low is detrimental to the shareholders.
And so then I take it that your 9.3% recommended ROE strikes a balance between those competing interests and, in your opinion, is in the public interest.
I am fully confident that that number balances my duty to balance the public interest.
All right, that's all I have. Thank you, Madam Hearing Examiner.
I also allocated 5 minutes for recross. If you want to participate in recross, raise your hand, please. Okay, I'll give Mr. Zadowski and Ms. Stevens each 2.5 minutes. Mr. Zadowski, you can go first.
Thank you, Madam Hearing Examiner. Mr. Tupler, do you recall being asked by counsel for the city about increasing equity ratios and potentially about increasing equity ratios and potential increasing costs for customers?
Objection. He's asking about the city's cross, not the redirect. I think that's outside of the scope of recross here.
Sustained.
Madam Hearing Examiner, I would just point out that EPE, according to your order, had the right to go last, and we would have had the benefit to hear Ms. Stevens' questions had the order been applied in that manner.
I'm still sustaining the objection.
Okay. Mr. Tupler, would you agree that as more equity is added to a firm's capital structure, both the cost of debt and the cost of equity should decrease?
I think this is also outside the scope of the redirect. I don't think Mr. Bagaco asked any questions about that. Am I right, Mr. Bagaco?
That's correct, Madam Hearing Examiner. I just didn't object because I wanted to sick my expert on him, but whatever you say.
So I'm not going to allow that line of questioning.
Okay. I have no further questions, and thank you.
Ms. Stevens?
Hello again, Mr. Tupler. I do want to follow up on a question that Mr. Bagatko asked you about how the discovery responses that you received after you filed your direct testimony affected your recommendation on return on equity. And you talked about a balancing now. Am I correct in understanding, based on your supplemental testimony and a discovery response to the city, that the information that influenced you had to do with EPE's debt covenants and this idea of the make-whole provisions?
Well, that was part of it. I simply hadn't seen the portfolio of debt at the time of our testimony deadline, but I know it's a major factor in this case, so I wanted to understand it a little bit better before I came up with a specific number. Like I mentioned, I used the 9% originally described in my direct testimony as a placeholder until I had full information.
And did you state that in your direct testimony? I don't recall seeing that.
I don't believe I used the terms. It's just my writing style at this point. It was not intentional by any means.
Okay. I know I have very little time here and I just momentarily lost you. So is it true that in your direct testimony, you described EPE's overall level of average level of cost of debt of 5.4% as being above normal levels and materially higher than what is fair, just, and reasonable?
That is my opinion.
And given that, what is it that justifies awarding EPE a higher return on equity than they otherwise would recommend now that you know more about that debt? I mean, just theoretically and in terms of your own reasoning.
I believe my initial concern about the debt was that maybe there was a oversight as to previous analysis maybe of the debt portfolio. I simply hadn't had an opportunity to review it. It was not touched on too dramatically in previous cases, so I didn't have a lot of historic decision to form any opinion, which is why we put the interrogatories together to get me a satisfactory explanation of the management of the debt portfolio.
Ms. Stevens, your time is up.
I'll ask Mr. Shana. Thank you, Mr. Tupler.
Yes, ma'am.
Thank you very much, Mr. Tupler. You're excused.
Thank you.
And Mr. Bogacco, you may call your next witness.
Thank you, Madam Hearing Examiner. We call Gabriella Dacheneau to the stand.
Ms. Stevens, that number you just mentioned, was that 5.4?
Yes.
Thank you. Ms. Dacheneau, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Ms. Dacheneau. How are you?
I'm good. How are you?
I'm all right. Well, we got a little work cut out for us here. I understand you filed some testimonies in that case. Is that correct?
That's correct.
Well, let's start with your prepared direct testimony that was filed on October 9th, 2020. And I hope you have a copy of that in front of you, do you?
Yes, I do.
That's been provisionally marked as Staff Exhibit 8, correct?
That is correct.
Take a moment to flip through that and make it sure that it is a complete and accurate copy of your direct testimony filed in this case.
Yes, it is.
All right. Now, my next question is this. If you were asked the same questions posed there in Staff Exhibit 8 today at this public hearing, would your answers still be the same as those reflected in that document?
Yes, they would.
And I take it you don't have any changes or corrections to make to Staff Exhibit 8, correct?
That's correct.
Well, with that, Madam Hearing Examiner, I'd move for admission into evidence the prepared direct testimony of Gabriella Dacheneau, which has been marked as Staff Exhibit 8.
Is there any objection? Staff Exhibit 8 is admitted.
All right, next up, Ms. Dacheneau, we've got prepared supplemental testimony that was filed in this case on December 17th, 2020, and I trust you've got a copy of that in front of you, correct?
That's correct.
And that's been provisionally marked as Staff Exhibit 9.
Correct.
All right. You would take a moment to flip through that and make sure it is a complete and accurate copy of your prepared supplemental testimony.
It is correct.
Now I would direct your attention to page 2 of that document down there on line 17. Do you see that?
Yes.
Do you see those handwritten corrections that were put into the document before it was uploaded to Dropbox in this case?
Yes.
Are those corrections consistent with your directives and what was detailed in the errata that was filed in this case?
Yes, they are.
All right. Do you have any other changes or corrections to make to this document, Ms. Dashino?
No.
And finally, if you were asked today the same questions posed to you in your supplemental testimony, would your answers be the same as those reflected in that document?
Yes, they would.
With that, Madam Hearing Examiner, I would move this document, prepared supplemental testimony of Gabriella Dashino, into evidence, and it's been marked as Staff Exhibit 9.
Is there any objection? Staff Exhibit 9 is admitted.
We're not done yet, Ms. Dashino. You also stepped up and volunteered to adopt and sponsor the direct testimony of Beverly Eschberger, whom we unfortunately lost to other employment. And although we dearly miss her, the show must go on. So I hope you have in front of you what has been provisionally marked as Staff Exhibit 4, which is Ms. Eschberger's direct testimony that was filed in this case on October 9th, 2020. Is that correct?
Yes. That is correct.
And are you here today to sponsor and adopt this testimony in its entirety?
Yes, I am.
Are you prepared to answer any questions directed towards this direct testimony from Ms. Eschberger?
Yes, I am.
So in essence, Ms. Eschberger's testimony is now your own, correct?
Yes.
All right. If you'll take a moment, flip through that and make sure that it is a complete and accurate copy of the testimony by Ms. Eschberger that was filed in this case.
Yes, it is.
And if you were asked the same questions posed in that document today at this public hearing, would your answers still be the same as those that are reflected in the direct testimony of Beverly Eschberger?
Yes, they would be.
With that, Madam Hearing Examiner, I would move to admit the direct testimony of Beverly Eschberger as sponsored and adopted by Gabriella Dashino into the record as Staff Exhibit 4.
Is there any objection? Staff Exhibit 4 is admitted.
Thank you, Madam Hearing Examiner. I would now tender Ms. Dashino for cross-examination by the parties.
Okay, Ms. Olson, you have 45 minutes.
Madam Hearing Examiner, before I start my cross-examination, in light of the ruling in Mr. Tupler's testimony, EPE is requesting that the order of cross ordered in your procedural order be followed and EPE be allowed to go before staff.
No, I'm not changing that.
Okay. Good morning, Ms. Dashino. Sorry, I'm gonna change my screen real quick so I'm looking at you. And it's nice to meet you. I don't believe we've previously met. My name is Carrie. I'm a lawyer for Montgomery and Andrews here in Santa Fe, representing EPE in this proceeding. So I'd like to first ask you questions regarding your testimony of staff's recommended revenue requirement and cost of service adjustments. And then I have a few questions for you about the treatment of excess ADFIT addressed in Ms. Eschberger's testimony.
Okay.
So you present you present staff's cost of service, correct?
That's correct.
And by cost of service, you mean staff's proposed revenue requirement, is that correct?
That is correct.
Okay. And do you understand or know that EPE filed an alternative jurisdictional cost of service?
Yes.
And this alternative cost of service supported by EPE witness Hernandez reflects the increased allocation of existing EPE resources to fill the energy and capacity deficit if PV3 is no longer used to provide service to New Mexico and the associated costs. Is that your understanding?
Okay, repeat the question for me,
Sorry,
please.
that was a long question. The alternative jurisdictional cost of service supported by EPE witness Hernandez allocates the additional generation and associated costs to New Mexico if PV Unit 3 is no longer used to serve New Mexico. Is that your understanding?
That's correct, yes.
And was the revised cost of service that you presented in your supplemental testimony, that's not based on EPE's alternative jurisdictional cost of service, is it?
No, it is not.
And so it doesn't include those costs. Is that
No,
correct?
that's correct.
And so staff's proposed revenue requirement assumes that PV Unit 3 continues to serve New Mexico. Is that correct?
That is correct.
Okay, thank you. And I just want to ask you a few questions briefly about your recommended adjustments, starting with staff adjustment. Well, in generally, is it correct that the recommended adjustments in your testimony are based on the testimony provided by some of staff's other witnesses?
Yes, that's correct.
So for example, your recommended depreciation adjustment is based on Mr. Sidler's testimony, is that correct?
Yes, and it's also based on my belief in rate shock and gradualism and increasing the rates of the customers.
So can you just quickly summarize your understanding of the concept of rate shock?
Yes, just increasing the rates too quickly for the customers.
But you don't disagree that staff's recommended cost of service would result in a rate decrease for customers, is that correct?
It would result in a rate decrease based on the adjustments that staff made, yes.
So the concept of rate shock to customers wouldn't necessarily apply when they're receiving a rate decrease, is that correct?
They're receiving the rate decrease based on the decrease in depreciation that we're recommending and our other adjustments. So specifically, because of those adjustments, they will not receive that rate shock.
Okay. In your recommendation to deny EPE's request to shorten the service lives of several of EPE's units is also based on testimony from Mr. Sidler, is that correct?
That is correct.
In turning to your recommendation for PV3 pricing, is your recommendation to use the day-ahead prices also based on Mr. Solomon's testimony?
That is correct.
Can we have a page number and a line number where you're working off of, just for clarity?
I'm just asking Ms. Dashino about her recommendations in her testimony. I'm not directing her to a specific page or line.
All right, well, thank you.
And do you know if the analysis that staff used for the proxy price for PV3, do you know, sorry, let me ask this question again. Do you know what proxy price staff used for its PV3 analysis?
Yes, the proxy price, give me 1 second. Let me just pull that up. Okay, so NYMEX futures, Palo Verde day ahead, that's what we would be recommending as far as the price.
And do you know what?
Can you spell NYMEX?
NYMEX.
Thank you.
You're welcome.
Ms. Dashno, do you know what the PV3 proposed proxy price you were comparing that against when you did the analysis?
The price that you guys are currently using is what we compared it against. Is that your question?
Yeah, there was a little bit of confusion yesterday in Mr. Solomon's testimony. Are you aware, he mentioned a $52 or $54 price, and I wanted to confirm with you, because I understand that you did the pricing analysis, that you used
Yes,
the
that's
40.
correct. So I came up with $53.47, which is what is currently being used by EPE. And that's for 2019.
Okay, is staff aware that EPE proposed a lower price in this filing?
A lower price, I believe you had a higher capacity cost in there though, if I'm correct.
So I'm not sure if you have Mr. Hernandez's direct testimony available. It's Exhibit AH6, and that gives the proxy price that EPE was proposing to use in this proceeding. If that differs from the $52 or $54 price that you're suggesting, I take that to mean that that wasn't the price that you were using for your analysis. Is that correct?
That is correct.
Okay. And moving on to your adjustment for the lead lags study, your testimony is that that adjustment is excessive. Is that correct? Or excuse
Could
me,
you
that
direct me? I don't recall that in my testimony.
Sure. Do you recall recommending that the cost for the lead lag study should be adjusted because that cost is excessive? The cost proposed by EPE is excessive?
No, could you direct me to the page and line in my testimony where I said that, please?
Sure. Do you recall making any recommendations regarding the lead lag study cost?
Ms. Olson, she asked you for a page and line reference. Please give her that first.
Well, Madam Hearing Examiner, I'm asking her if she's making a recommendation.
And she's asking you for a reference, which is legitimate.
I believe the recommendations that you provide in your direct testimony for adjustments are listed from page 5 through page 7. And
I found it, yes. Okay,
Okay.
so this is in the rate case expense. And could you repeat your question for me, please?
yes, is it your testimony that the hourly rates that EPE paid for the lead lag study are excessive?
Yes, that is correct.
And have you provided any support in your testimony for that determination?
Yes, I believe my answer was in response to that, and I'll read it from my testimony at line 8. Staff continues to argue for rate continuity and gradualism and does not support the excessive cost and hourly rates paid to perform the lead lag study, particularly in comparison to the cost and hourly rates of the depreciation study.
So am I correct in understanding that your basis for determining that the lead lag study was excessive is because of the cost of the depreciation study?
It's an excessive charge to customers. And the lead lag study, I believe, I don't know if I'm allowed to reveal the cost that EPE paid for it. So I'm just gonna leave it at that.
Madam Hearing Examiner, if I may, for clarity, dash note, what you are reading from was page 6 of your direct testimony, correct?
That is correct.
All right, thank you.
And have you done any comparison against the cost of other lead lag studies?
I did not do that comparison.
And do you have any basis for determining that typically a cost of a depreciation study and a cost of a lead lag study should be similar?
I believe a cost for a depreciation study would probably be more expensive.
And
as
what's
it
the,
all- That's just the involvement of everything.
and what is the basis for that opinion?
Well, the depreciation study has to involve a lot more accounting versus a lead leg study. And that's my opinion.
Okay. And what is the basis that the lead lag study cost, this is at page 6, line 12, should be decreased by 50%?
That's just in order to decrease the amount that the customers are going to pay for this study. And as I read from my testimony, that has to do with gradualism.
And how did you arrive at 50%?
That was the analysis that I chose to use to make a recommendation to reduce those expenses.
Okay. Turning to Ms. Eschberger's testimony on accumulated deferred federal income tax, which I'll refer to as ADFIT. Do you have Ms. Eschberger's testimony in front of you?
Yes, I do.
Excuse me, Ms. Olson, for the court reporter, could you repeat, did you say excess ADIT or did you use a different term?
Oh, I was just, I read the words accumulated deferred federal income tax, which is abbreviated as ADFIT.
Okay, thank you.
So you've adopted the testimony of Ms. Eschberger, correct?
That is correct.
And you're supporting staff's proposals to amortize the company's excess ADFIT resulting from the enactment of the Federal Tax Cuts and Jobs Act. Is that correct?
I support that, but I do understand after adopting the testimony and reading the laws of the rules of normalization that, EPE really doesn't have a choice in using the 50-year amortization.
So you understand that if the commission were to
For
adopt...
the protected.
So you understand that if the commission were to adopt staff's recommendation regarding the amortization of the company's protected excess ADFIT, that would constitute a normalization violation?
Yes, I do.
Okay. And a normalization violation is bad for ratepayers. Is that your understanding?
Yes.
And that's because the company would no longer be able to use accelerated depreciation.
That is correct.
Okay.
I understand. Yeah, I'm sorry.
Perfect. Well, I appreciate your time this morning, Ms. Dacheneau, and your testimony in this case. And I apologize. Yesterday, I didn't get to thank Mr. Solomon for his time and testimony. So if you could please pass that on to me, I would appreciate it. I have no other questions for you.
Thank you.
Ms. Stevens, you have 15 minutes.
Thank you, Madam Hearing Examiner. Hello, Ms. Dacheneau. I'm Anastasia Stevens. I don't think we've met before. I represent the city of Las Cruces. And I have just a couple of follow-up questions. One revolves where I left off with Mr. Tupler, and one is early in Ms. Olson's cross-examination. She was Ms. Olson was asking you about the alternative cost of service that the company prepared on the theory that they would need to allocate more capacity costs to New Mexico ratepayers if the commission does not accept their proposed proxy price. Is that correct?
That's correct.
Yeah. And my question to you is, has staff taken a position either through yourself or Mr. Solomon that generation cost will necessarily have to be reallocated to New Mexico customers if the commission does not accept the $48.50 cent per MCF price that the company is proposing in the most recent modified version of the proxy.
I did not make that recommendation myself, and I am unaware of Raj making that. Raj
Thank-
Solomon making that recommendation.
Thank you. That was my understanding. I wanted to. Now let's go to where Mr. Tupler left off. And I'm going to ask you to, I don't believe that you have specifically quantified in your written test, either of your own written testimonies, the dollar effect of the capital structure and return on equity provisions. So I'd like you to turn to your exhibit. Whoops, I haven't got Eschberger open in front of me. If you would turn to the exhibit GSD1 sup in your supplemental testimony, and the exhibit I think it's GSD
One sub.
1, yeah. No, not the GSD 2, it must be, because I'm seeing GSD 1 is the GSD 2 in your direct testimony.
Okay, my direct. Give me one second.
And if you could, so that's
So we're looking at GSD.
GSD 2 of the direct, which is page 17 of 20 of the PDF that I'm looking at. And
Okay.
I don't have double screens here. And GSD 1 sup on page 6 of 8 of the PDF in the other. So what I'm asking you to help me with is how can we quantify the difference between the staff's originally proposed return on equity, the effect of the staff's originally proposed return on equity of 9.0% versus the revised return on equity of 9.3%. And I see here on GSD 1 sup that we have a total dollar requirement on the far right hand column, the third row, that I assume this is at the revised with the 9.3%.
Yes,
is that correct?
That is correct.
So you have a total recommended return on rate base of $34,590,052. Is that right?
That is correct.
And then flipping back to original GSD
Right. We just
2, that's done on a class basis. And have I missed something? Is there oh, here it is. I take it back. Yeah, it's on page 7 of, no, is that?
Okay, let me get where you're at.
Yeah, I'm trying to find where you've broken down the comparable amount for total return on rate base. Because would that be the right way of determining the
Yes,
effect?
I know what you're asking. I'm not
basis.
sure that in that first, I believe when I filed my direct testimony, I considered that portion as a work paper. So I didn't
Yeah.
fill it with
Okay.
my testimony.
Ms.
So I have that
Stevens,
number
don't-
and
I'm
I'm
sorry,
sorry, what was
Ms.
that?
Stevens was talking over you. I was just going to ask her not to do that. Go ahead and continue, Ms. Dashino.
Okay, so I do have that number. I didn't file as an exhibit. I considered it my work paper when I did my direct testimony. So if
What is the number?
you
Do
will
you have that number?
to get that number for you, I will get that for you. Give me 1 second. Okay, let's see. Give me 1 second just to locate it in my files. Okay, I want to say, you know what, I do not have that.
Do you think that we could?
I don't have it in the same format as this, so I couldn't give you that. I'm sorry. I thought I did, but it's.
Do you think that we could calculate it by looking at GSD2 in your direct and using the, on the second line there, the overall return of 7.2437% instead of the overall return that you used in GSD1 sup and apply it to the same rate base?
Okay, give that to me again. So exhibit GSD2, is that what you're telling me?
GSD2, you see across the board.
Right, okay, so you have your rate base, and then you have your overall return.
Right, and I think that if we go back to GSD
To-
sup, one sup,
Mm-hmm. And you're saying to change the, well, a rate base is more.
use that rate base times the earlier overall return, and we would get a different number from the 34,590. Can you do that
I'm
arithmetic?
following correctly against my SUP and against exhibit GSD2. The number that you're asking about in my supplemental 34,590,052 versus 33,814,638. And I mean, if I'm following it the way I would prepare it,
So you just ran it through your spreadsheet, and at the 7.2437% overall return, did I hear correctly?
that would be correct.
33,814,638.
Right. That would be my assumption. I'd have to go back and do the work, but I obviously don't have time to calculate it now.
Pardon. And if we subtracted that number from, I don't know why I'm pulling out my calculator, because you obviously can do this in a flash. If we subtract, if we took the difference between the 34,590,052 and the 33,814,638, what would that difference be, Ms. Tashino?
1 second. I get 775,414.
And would that be would it be that your testimony that is the effect of Mr. Tupler's change in the return on equity on the revenue requirement in this case?
I don't want to completely say that that is my testimony because I would want to have more time to review this, but that is the difference that I compute based on my supplemental and my GSD1 supplemental and my exhibit GSD2.
And do you think the method we used is at least a reasonable approximation of what the change in?
Yes, it's a reasonable approximation. Yes.
That's all I have. Thank you very much for your testimony. It's nice meeting you.
You're welcome.
Ms. Souls, you have 10 minutes.
I have no questions for this witness. Thank you.
Mr. Herman, you have 5 minutes.
Thank you, Madam Examiner. Good morning, Ms. Dacheneau.
Good morning.
Were you present during the cross-examination of NMAG witness Andrea Crane?
Yes, I was.
So I'm just an attorney here. I'm still trying to figure out all this tax stuff, and I wanted to see if you would agree. When I was cross-examining her, I just asked the simple clarification that protected excess ADIT was money owed to the customer, and that unprotected was money owed to the company. Would you agree with that characterization?
In this case, yes.
So I believe on cross, you just testified that you supported EPE's proposal to pay back the protected ADIT over a period of 50 years.
Yes.
And what was your proposal to pay back the unprotected ADIT?
The unprotected, the proposal that I'm recommending is 15 years.
So your proposal is that customers get their money back over 50 years and the company gets their money back over 15.
Yes, based on the IRS rules.
Okay, that's based on your understanding of the IRS rules. What do you happen to have a reference of the specific IRS rules?
Not right in front of me. I can try and get to that. I believe it's referenced in Ms. Eschberger's testimony.
Okay.
So
if the proposal didn't result in a normalization, or if, for example, the county's proposal to pay it back over 3 years did not result in a normalization violation, would you be more or less inclined to support a shorter time frame?
yes, and I believe staff in this testimony recommended 31 years. 3 years, I'm not sure. That's just not what we recommended. So as far as shortening it, it would be 31 years. But as I mentioned, understanding the normalization rules makes it harder to do that.
But ignoring the normalization rules or your understanding of them, you would be in favor of a faster time period to pay back the
That's
customers.
correct. That's correct.
Okay. And do you think that would be in the interest of fairness?
Oh, absolutely. If there wasn't that normalization rule, it would be great to get that money back to the customers in a shorter time period.
Bear with me for 1 second. I have lost my tab. But I believe I have no further questions. So thank you for your time today. It's good to see you.
Thank you.
Ms. Dacheneau, I have some questions that I gave you notice of. At page 2, line 10 of your supplemental testimony, you use the number 120,974,734 as EPE's adjusted test year period base rate revenues. In your direct testimony at page 4, line 6, you use the number of 120,828,994 as EPE's adjusted test year period base rate revenues. The 120,828,994 number is found at page 5, line 5 of Adrian Hernandez's second supplemental testimony. Which is the correct number?
The 128,28994. Wasn't comfortable with that number, but after hearing Mr. Hernandez's testimony and understanding that that was with the inclusion of non-firm revenues, I am comfortable with 128,28994 as being the correct number.
Okay, if that number is the correct number, am I correct that staff's recommended dollar revenue decrease is 1,043,316, and that staff's recommended percentage revenue decrease is 0.86%? Negative.
That is correct. Yes, negative 0.86. You are correct.
Okay. And then I have one more question based on your testimony today. Does your recommended revenue requirement in your supplemental testimony reflect, I'm going to say, staff's change in position with regard to the amount of time that should be used to return protected excess ADIT?
It reflects staff's position. Yeah. I'm sorry, protected. No, it doesn't. So I would have to change that to the 50 years.
Okay. Thank you. That's all the questions I have. Mr. Bagatko, I allocated 5 minutes for a redirect if you have any.
Madam Hearing Examiner, we can dispense with redirect for Ms. Dashino. I thank you, though.
Okay, thank you very much, Ms. Dashino. You're excused.
Thank you.
Let's go ahead and take a break right now and come back at 10:40.
Keep your mics on. We're hearing some background noise from you.
Ms. Olson, are you doing labor tercero?
Yes, sir, I am.
Thank you, ma'am. You're on mute, Miss labor tercero.
Thank you.
You're welcome.
David, are you ready?
Yes, Your Honor.
Let's go back on the record, and Mr. Bagatko, you may call your next witness.
Madam Hearing Examiner, before we move on to Ms. Tercero, I understand that Ms. Dashna was already excused, but I was wondering why you didn't give the company an opportunity to recross on your questions.
Oh, you're right. I should have. I was thinking because Mr. Bagatko had no redirect that there wouldn't be any recross, but you're correct. Mr. Bagatko, would it be possible to have Ms. Dashno come back on?
You're on mute,
You're
Mr.
on mute.
I'll give her a call. I believe it will be. Just give me a moment.
I
Okay,
really
thank
appreciate
you.
it. Thank you both. I apologize. I was trying to get it out before the break and the audio wasn't going through.
Madam Hearing Examiner, Ms. Dashno should be back with us momentarily.
Thank you very much, Mr. Bagatko.
You're welcome. All right.
Thank you, Ms. Dashno. I'm sorry about that. Ms. Olson reminded me that I should have given her 5 minutes to ask you questions about my questions. So that's
Okay.
what's going to happen right now.
Okay.
Go ahead, Ms. Olson.
Thank you. And Ms. Dashna, I apologize for the confusion and appreciate your willingness to briefly come back. I just wanted to clarify for the record, I believe there was a little bit of confusion with the questions you were asked about.
I'm sorry, could you repeat that? I was frozen for,
Oh, sure. I just wanted to clarify for the record, because I believe you started testifying about a 50-year, and I just wanted to be clear that you're agreeing with the company's position that the IRC requires the use of the ARAM method to amortize the protected excess federal ADFIT. Is that correct?
I agree with that.
Okay, thank you. I don't have any other questions.
Okay.
Thanks, Ms. Daschino. You're excused.
Thank
Again,
you.
I appreciate you coming back. Thank you very much.
Okay, Mr. Bagaco, you may call your next witness.
I call our final witness, Alicia Tercero. Stand, please.
Ms. Lebater, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Good morning, Ms. Lebater. How are you?
Good morning. I'm doing well. How are you?
All right, thank you. It looks like you filed some prepared direct testimony in this case on October 9th, 2020. Is that correct?
That's correct.
And I trust that you have a copy of that in front of you.
Yes, I do.
You see that it's been provisionally marked as Staff Exhibit 10.
Yes.
Would you take a moment to flip through that and make sure that it is a complete and accurate copy of your prepared direct testimony, Ms. Lebater?
Yes, it is.
And I trust that you don't have any corrections to make to this direct testimony today, do you?
I do not.
Thank you. And then finally, Ms. Lebater, if you were asked the same questions today in this public hearing as what are posed in your prepared direct testimony, would your answers to those questions still be the same?
Yes, they would, given the information that I had at the time. However, I would note that staff has since revised its revenue requirement as indicated in the supplemental testimony of Ms. Daschino.
Ms. Leyba-Tercero, we couldn't hear you for a minute. Could you go back and state, I think you were saying it was correct at the time you filed it, and then start from there?
Yes, but so I would note that staff's revenue requirement was revised as indicated in the supplemental testimony of Ms. Daschino. And so I was not asked to file supplemental testimony to reflect the impacts of staff's revised revenue requirement on staff's allocation and rate design. However, that would change.
Thank you for that, Ms. Lebater. Well, with that, Madam Hearing Examiner, I would move for admission of the prepared direct testimony of Alicia C. Lebater into the evidentiary record as Staff Exhibit 10.
Is there any objection? Staff Exhibit 10 is admitted.
I would tender Ms. Lebater for cross-examination by the parties.
Ms. Olson, you have 45 minutes.
Thank you, Madam Hearing Examiner. Good morning, Ms. Leyba-Tercero. Again, I don't believe we've previously met, so it's nice to meet you. My name's Carrie Olson. I'm an attorney here in Santa Fe representing El Paso Electric in this case.
Good morning. Nice to meet you.
Thank you. I understand you're the staff witness that reviewed the company's proposed jurisdictional cost of service. Is that correct?
Correct.
The class cost of service, is that also correct?
Correct.
And the allocations, is that correct?
Correct.
And rate design.
Yes.
And are you aware that EPE also filed an alternative jurisdictional cost of service?
Yes, I am aware.
I don't know why I'm having such a hard time saying cost of service this morning, but it's not coming out very easily. And you understand that this alternative jurisdictional cost of service supported by EPE witness Hernandez allocates additional generation and its associated costs to New Mexico if PB3 is no longer used to provide service to New Mexico. Is that your understanding?
Yes, that's my understanding.
And do you agree that the alternative cost of service study shows that if EPE no longer uses PV3 to serve New Mexico, additional generation resources will be required to be allocated to New Mexico to provide the deficit in that service?
That's my understanding.
And do you agree that the alternative jurisdictional cost of service shows a $1.7 million cost associated with the allocation of those additional resources?
I don't recall, but subject to check. Yes.
Do you recall that it shows an increase in cost? You just don't recall what that exact increase is?
Yes.
Okay. And do you agree that EPE's New Mexico customers should pay the cost of service that's required to provide service to them?
I would agree that New Mexico customers should pay the cost of service that, yes, that is required to provide service to them that is approved by this commission.
So we're in agreement that New Mexico should pay the cost of service that's required to provide service to them.
Objection asked and answered.
Sustained.
So yes, I would agree, assuming that that is approved by this commission.
Okay. Ms. Leiva-Tercero, I appreciate your time this morning. Those were the only questions I have for you.
Thank you.
Ms. Stevens, you have 15 minutes.
Thank you. Hello, Ms. Leiva-Tercero. Nice to see you. And I didn't expect I would have more questions than the company. But let me follow up with the question that Ms. Olson just asked. As I heard her question, she asked, do you agree that the alternative cost of service study that the company proposed shows that additional generating resources will have to be reallocated to New Mexico? And your answer was, that's my understanding. And I was wondering whether that's your understanding of the company's position or of staff's position.
That is my understanding of the company's position.
Thank you. Now let's turn quickly, since I only have 15 minutes, to some of the rate design issues. And I'm, of course, in your direct testimony, since you only filed direct testimony. And I would like to thank you. I know you're ordered to, but I'm really impressed that you're going through the whole process of doing a full class cost of service analysis. That was heroic and impressive. Although, of course, it's going to change when there's a different revenue requirement, but thank you for that. On page 6, lines 4 through 8, you appear to agree with the company's use of a 4CP allocation methodology for peaking generation resources. Is that correct?
Yes, that's correct.
And before accepting the company's proposed change in allocation methodologies, did you or any other staff members analyze the actual patterns of how EPE uses these so-called peaking units?
My recommendation was based on my understanding of the company's analysis, which appeared to be reasonable to me.
And my question was, did anybody actually go in and check on how those individual peaking units have been used historically?
No, I did not do that.
Do you know whether any other staff member did that to assist your recommendation?
I don't believe so.
Let's turn to pages 8 through 9 I have in my notes. And this is where you discuss generally discuss the allocation of the proposed non-fuel revenue requirement. Given this is a general question, given the current proposals of staff, the Attorney General and the city and the county for an overall revenue reduction, would you make any changes in your recommendation to the commission that it use ceilings or possibly even floors for allocating a revenue decrease among revenues in light of a decrease in revenue requirement?
Yeah, I think that would be reasonable to have ceilings and floors. I have not done that analysis based on staff's revised revenue requirement, but there would be changes to what I originally proposed.
And very generally, would those changes provide under those changes, would you wish to see, would you be in support of residential customers receiving any revenue increase, class revenue increase?
I think likely the residential class would not receive an increase.
And would that be true of other classes as well?
Yes.
So the challenge for a rate design would be to distribute the decrease in a manner that achieves some progress towards unity or paying each class's cost of service. Is that general theory?
Yes, that's correct.
Now on page 13, you recommend a $9.74 residential customer charge. In light of a potential negative revenue requirement, would you still recommend an increase from $7 to $9.74 for residential customer charge, fixed monthly charge?
Again, I have not done that analysis, but I would likely not recommend a decrease in the customer charge, but I would either recommend that it stay the same or that there be an increase to a lesser extent than what I had proposed in my direct testimony.
Thank you. Page 16 of your testimony, please. And here you express support for making the city county service rate number 7 mandatory for new customers. Were you here for Mr. Carrasco's direct testimony or oral testimony, Ms. Labor-Tucero?
I'm sorry, can you direct me to the page again?
Yeah, page 16, lines 14 to 19.
Okay, I'm sorry, I'm there.
And the question was, does staff agree? That was where the agreement aspect of it. But were you here for Mr. Carrasco's testimony?
I believe I was for most of it.
And for Mr. Provencio's testimony?
Yes.
And for Mr. Bacchus's testimony?
For parts of Mr. Bacchus's testimony.
In general, well, let me just put it this way. Why do you support making time of day rates mandatory for the city county service rate?
Are you talking about rate number 8? I don't believe that rate.
Rate number 7, it's on page 16. Are you with me? Did you get to say page 16, lines 14 through 19?
I didn't understand that rate number 7 would be mandatory. time of day rate. It's my understanding that rate number 8 would be mandatory for new service options.
Well, we'll move on from that because I don't have much time. In general, though, listening to the other witnesses' testimony and have it based on your own large background in rate design, do you believe that mandatory time of use or time of day rates are more effective than voluntary ones?
Yeah, I think that that would be a reasonable assumption, that moving to mandatory time of day rates would be more effective, but I wouldn't recommend immediately moving to mandatory time of day rates.
And I guess we should define effective. Is that, by effective, do you mean effective in getting customers to shift their usage off peak? Is that what I want to be sure we're using the right terminology, same terminology?
Well, when the rates are optional, you have customers may not choose to participate in a time of day rate. If they're mandatory, then the customers have to, and unless they, if they want to avoid increased charges, then they would shift their usage to on off peak.
And do you think that system benefit, and this is again based on your entire experience, do you think that system benefits can be achieved by offering voluntary time of day rates and encouraging interested customers in taking advantage of those rates, shifting their load off peak and achieving savings with a net benefit to the system as a whole because they have moved load off peak?
Yes, I believe so.
Now, pages 17 to 18 of your testimony, this is where you discuss the electric vehicle. Well, actually, it's the bottom of 16 through 17 to 18. You describe the proposed new electric vehicle charging rate. Does staff support the city's proposal to open that rate to larger commercial type users who take service at 480 kilovolts as well as 240?
Yes, I would support that, and I believe that the company has proposed that in its transportation electrification plan.
And do you support that in this case as well before the transportation electrification plan takes effect?
Well, I had not indicated that in my testimony, but after reviewing the testimonies in this case and the company's willingness to include that, yes, I support that now.
Thank you. Now, I think so page 20 of your testimony. This is, I'm at page 20, and we're talking about the residential at the bottom. We're talking about the residential time of use at the bottom of page 20. This is kind of a general question because you go on for a couple of pages about that. But this bill protection provision, the bill protection provisions that EPE is proposing in some of the situations in which time of use, time of day, I'm going back to old-fashioned time of day rates are optional. Has staff, have you made any determinations about whether those provisions are used in other jurisdictions and have the desired effect in other jurisdictions?
Bill protection provision?
Bill protection provisions, basically an opt-in and opt-out of a time of day rate.
I think I would see that as a different thing, but I believe that I have seen the use of bill protection provisions, and I believe that they are helpful.
Have any other either of the other two New Mexico electric IOUs used bill protection provisions such as EPE is proposing in this case, as they have transitioned to time of use, time of day rates?
Not that I'm aware.
Are you at all concerned about the numerical limits that EPE has chosen for its bill protection revisions in several of its rate classes.
Well, that was one of the things that I indicated in my testimony, is that if that limit has been reached, then customers should be notified of that if there are customers above that limit. But based on the current participation, I think maybe it would be reasonable to assume that we would not have participation over that level, at least not yet. I think that participation will probably increase, but.
And I think, are you referring to, with respect to the residential class, the evidence there are 20 customers now, and the fact that EPE is proposing to offer the bill protection clause to the first 250 in rate 1?
Yes, that's correct.
Do you understand that 250 is a very small percentage of EPE's total residential rate class?
I do understand that.
Do you have any ideas of your own for broadening the use of time of use rates, time of day? God, there I'm having my problems. Time of day rates for residential customers who do constitute a very large portion of EPE's New Mexico class.
Well, I believe that EPE's proposals are reasonable. Of course, more can always be done, but I think that EPE is making strides in its current proposals to try to increase participation, not only through the bill protection provision, but from decreasing the on-peak hours from 8 hours to 6 hours, and shortening the summer season from 6 months to 4 months, and more aggressive marketing. I think that all of those things will be helpful in encouraging more participation.
And do you recall when Mr. Carrasco was being cross-examined, a discussion of his, and now I'm forgetting the exhibit number, but the analysis that showed that residential customers would pay $17, almost $18 more per month if they switched. Average usage residential customer would pay almost $18 more per month if they moved to time of day rates and did not alter their behavior by, I think Mr. Carrasco described it as 16%, shifting 16% of the load. Are you familiar with that evidence?
Yes.
Does it trouble you that the specifics of what EPE has proposed do require that significant level of behavioral change before a customer will actually even break even, let alone see a benefit?
I'm sorry, I didn't quite understand your question. Could you repeat it?
Yeah. Is it troubling to you that according to that evidence of a residential time of day customer who takes who will need to, in the summer months, shift 16% of his or her load to off peak in order to essentially break even on their monthly bill?
I think, like I said, I am not opposed to EPE's proposal. I think that is one of the incentives of the time of use rate. I mean, you have to shift your usage to off peak to be able to realize those savings.
And
Ms. Stevens, your time is up.
thank you. Thank you, Ms. Leibich-Asura. Good to see you.
Thank you. Good to see you too, Ms. Stevens.
Ms. Souls, you have 20 minutes.
I'm hearing examiner. I have no questions for this witness.
Okay. Mr. Herman, you have 5 minutes.
Thank you, Madam Examiner. That won't be necessary. I do not have any questions for Ms. Leyva Tesoro either.
Okay. Mr. Smith had requested 20 minutes, but he is not present, so he waives his cross-examination. Mr. Marks, you have 15 minutes.
I just got to be different. I'm not going to waive.
What?
I said I've got to be different. I'm going to
Oh,
ask some questions.
okay.
Right. Thanks. And Ms. Leyva Tesoro, I'm going to continue in the same area Ms. Stevens was discussing with you, the residential TOU or TOD rates. And you told her, she asked you what you did to analyze the bill protection plan, but I wasn't clear about your answer. Did you do any quantitative analysis or empirical analysis to determine that the bill protection plan would be effective in increasing subscribership?
No, I did not. I have seen that it is used in other time of use rates. And from my perspective, I think that it would be helpful to me if I were thinking of switching to a time of day or time of use rate. And I was worried that maybe I wouldn't be able to switch my usage to shift my usage to off peak. Then having that protection in there would encourage me to participate.
Would you agree with me that the bill protection plan provides a backstop or reassurance, but in and of itself doesn't provide a reason for a customer to switch to time of day?
No, the reason to switch to time of day would be to save money.
And for that to happen, there has to be a meaningful opportunity to reduce your bill.
Yes, I would agree with that.
Okay. And would you agree that the opportunity to reduce the bill is a function of the difference between the time of day off-peak rate and the standard rate?
Yes, I would agree with that.
Okay. And Ms. Stevens, you told Ms. Stevens that 250 customers is a pretty small percentage. Do you have a calculator there?
I can get one. Give me a second. Okay.
For the record, could you state what percentage of EPE's residential customers 250 customers represents?
Well, I don't know off the top of my head how many total customers that they have. Do you have that number?
Ms. Leyva Tesoro, if I represented to you that there's been testimony earlier in this case from EPE witnesses that they have approximately 88,000 customers, could you tell us what percentage 250 represents of that?
And I'm sorry, you kind of cut out for me. You said 88,000?
Yes, I did.
It's a very, very small percentage, less than 1%. So.
What is it, approximately 0.3%?
Yes.
Okay. And did you hear Mr. Novella state that a residential customer might have a peak use of 3 to 4 kilowatts?
I believe I recall that, yes.
Okay. If there were 250 customers and they were each able to save or avoid use of 4 kW on peak, do you know how much total peak savings that is?
I'm sorry, can you repeat those numbers again?
Sure. If there are 250 customers who are avoiding peak usage because of this program and they're able to each turn their use off entirely, so that's 4 kW saved, do you know how much total that would be?
About 1,000.
1,000 kW?
Yes.
And did you make any analysis of whether a 6-hour peak period is better than an 8-hour peak period?
I did not, but I would assume that a shorter period would customers would be able to. I'm sorry. Did you say 8-hour and 6-hour?
Yeah.
So yeah, I assume that the 6-hour period would be easier for customers to adopt than the 8-hour.
Would you agree by the same token that a 4-hour period would be easier than a 6-hour period?
Yes.
Okay. Do you have any reason to disagree with Mr. Bacchus that a too long on-peak period is a major barrier for customers in deciding whether to opt into the TOD rates?
I don't know that I can say it's a major barrier.
You agree it's a barrier based on what you previously told me, correct?
Based on
What you previously told me.
I agree that it would be easier to adopt a shorter period than a longer period.
Okay.
And the way I phrased it is, do you have any reason to disagree with Mr. Bacchus? Do you know anything contrary to that it's not a major barrier?
No.
Okay. On page 4 and 5 of your testimony, you agree that's appropriate to allocate non-peaking generation on 4CP A&E and use 4CP for the peaking demand. Do you recall that?
Yes.
Okay. Do you agree that if a customer is on a TOD rate, that customer's off-peak use is not occurring at any time when 4CP will be measured?
I would agree with that.
Okay. Should the time of day off-peak rate get any allocation of costs that are allocated on a pure 4CP basis?
You know, I'm not sure. I think I would need to look at that more to determine that.
Okay. And back to our less than 1%, 250 customers. Your testimony was you thought that EPE's plan was responsive to the commission's direction in the last rate case, that subscription or subscription rates for time of day should be increased. Do you think 250 is a big enough target to satisfy what the commission wanted in the last rate case?
I definitely think it's progress. I think that the subscription levels of time of use rates for all of our electric IOUs are low based on my understanding. And so, like I said, I believe that the proposals that EPE has made in this case, that the company is making strides in trying to improve its rates. And we don't know at this point whether or not those are going to be effective until we allow the company to implement them.
Nothing further.
Mr. Bagatko, I allocated 7 minutes for redirect if you have any.
Madam Hearing Examiner, no redirect necessary in this instance, but thank you.
Okay. And my question to you, Ms. Leyba Tercero, has been answered.
Thank you.
So thank you very much, Ms. Leyba Tercero. You're excused.
Thank you.
So that concludes the presentation of the evidence. I have a few things I want to discuss before we go off the record. Just a moment. Okay, first of all, this morning EPE emailed and filed a motion to strike testimony of intervener Mary Lee Souls. I am denying that motion. The reason that I'm denying that motion is that Mary Lee Souls filed her first supplemental testimony on November 23rd, 2020. A little over 2 months ago. And the first question and answer of that supplemental testimony is, please state your name and address. Answer, my name is Mary Lee Souls, and I currently reside at 3047 37th Avenue West, Seattle, Washington. So I find that EPE was on notice over 2 months ago that Ms. Souls no longer resided in New Mexico, and that there was too much of a delay in bringing this motion. I am making no determination regarding whether Ms. Souls, as a non-resident and non-customer of EPE, has an interest in this case. I am denying it. I'm denying EPE's motion again, based on the delay in filing the motion. Regarding briefing, initial post-hearing briefs shall be filed on or before February 16th. Response brief shall be filed on or before February 24th.
Madam Hearing Examiner, did I hear 15th or 16th? I'm sorry.
Initial briefs, February 16th.
16th, thank you.
I will be issuing a briefing order this afternoon that has issues that I would like you to brief. I'm not going to go over those here, except I am going to go over one thing that will be in my briefing order. I will bring it up on the share screen, and it relates to Commission Rule 1.2.2.36F. And I don't think you need to bring that up as we're talking about this. That section is entitled Reconciliation Statements and contains information that shall be included in a brief in a rate case unless the presiding officer directs otherwise. And I am going to be directing otherwise in my briefing order. I'm going to require EPE to comply with F1 because I think the information required would be useful to get from EPE. I don't know that it would be particularly useful for me to get the information required by F1 from interveners and staff. So I'm going to pull up now what I am going to encourage, or what my briefing order will say would be the most helpful information for me to receive from interveners and staff who are recommending a particular revenue requirement. Okay, so You can see at the top, I've put in EPE's adjusted base rate revenues, its requested revenue requirement, and its requested base revenue increase, if I've calculated all those correctly. If you think I haven't, you can substitute those numbers with what you think are the correct numbers. Under that, I have intervenor staff adjustments to EPE's requested revenue requirement. And what I would like you to do, I have 3 examples under that of recommended adjustments that I know some of the parties are recommending. For instance, the first one is reduce return on equity. The second one is reduce rate case expenses. The third is reject shortening useful lives of natural gas generation units. So for each adjustment you are recommending, what I would like you to do, what would be helpful for me, is to name it, like reduce ROE to whatever, and then in the next column over, put the dollar amount of the reduction to EPE's requested revenue requirement associated with that adjustment. And then you'll see a footnote after reduce ROE to, and that says provide a citation to the admitted exhibit or transcript which supports the adjustment. And then below that, to put in intervenor or staff's recommended revenue requirement. Below that, your recommended increase or decrease in dollars. And below that, your recommended revenue increase or decrease in as a percentage. I'm only requiring this for those of you that are actually recommending a particular revenue requirement, although I will point out that our commission rule 1.2.2.36 F2 allows staff or a party to adopt the position of another party or staff. So if you yourself are not recommending a revenue requirement or haven't provided testimony on that, you can adopt a recommended revenue requirement of another intervenor or staff. So does anybody have any questions about that exhibit that I've put up?
Madam Hearing Examiner, this is Anastasia Stevens. I'm just wanting to confirm that these are all these numbers will be on a tax adjusted basis for the New Mexico jurisdiction. Is that correct?
Yes, I would like that.
Thank you. That works with our exhibits.
Madam Hearing Examiner, this is Keith Herman. Will you be sharing this Exhibit A?
Yeah, it'll be an exhibit to my briefing order.
Okay, I was hoping for a Word format as well.
Okay, I'll do that. If I forget, you can email me and remind me, and I'll send out the Word version.
Thank you.
I think I understand that exhibit, Madam Hearing Examiner. I do have one minor concern about the briefing schedule, if I may.
Go ahead.
I'd be remiss if I didn't ask for a little bit more time on the response. It's only an 8-day period in there, and our experience as the utility is oftentimes people are filing briefs many hundred pages, and the utility typically has to be addressing all of those issues. And I'm simply concerned that we will not have enough time between the 16th and the 24th in order to evaluate and properly respond to all of the issues that are raised.
Are you recommending a particular date?
Yes, I guess I would You're currently talking about the 24th. I guess I would request until March 2nd, which is a Tuesday.
Does anybody object to that? Okay, I'll give you that.
Thank you.
The last thing is that I think the other hearing examiners in rate cases, we put together a committee comprising some of the witnesses in the case. In this case, it would be to assist me in assuming I do not recommend everything that EPE is proposing. This committee would help me to come up with different numbers, possibly different cost allocations, different rates based on my recommendation on my recommendations on the litigated issues in the case. And so the members of the committee that I am going to name are for EPE, Adrian Hernandez, Jennifer Borden, and Manuel Carrasco. It's possible that I'll need to bring in another EPE witness or two. You know, I hope I've asked Ms. Nelson to do enough calculations of ROE that I wouldn't need any more from her, but it's possible that I might, in which case I'd probably bring her in. For the city and the county, Mark Garrett. For the Attorney General, Andrea Crane and Doug Gigax. And for staff, Gabriela Descheno and Alicia Labor-Tessero. And I'll just tell you that, you know, the EPE witnesses on the committee are going to be doing most of the work. The other witnesses that are on the committee, their main purpose is going to be to review EPE's work. I anticipate I will be having discussions with the committee beginning mid to late February through mid-March. I mean, I may have the committee start running some numbers for me before I've received all the briefs, just to kind of get going based on some of my preliminary thoughts. If a member of the committee is not available during that time period, if the work can be done without that member, it's going to be done without that member. If the member's not available for some reason and his or her input is necessary, I'll address that when it comes up. I will be emailing out a confidentiality agreement that I will require each member of the committee to sign and file and serve. I think that's all I have.
Madam Hearing Examiner?
Yes, Mr. Marks.
I was pleased to hear that you've already planned to do a committee of witnesses, because this is obviously a complex case financially with pretty big spreads. We've heard in this hearing so far that when it gets down to the rate design, and obviously my client is most interested in, or solely interested in rate design at this point, but when it gets down to the rate design, it's as much an art as a science, and we've heard EP's witnesses acknowledging that certain factors were selected and maybe based on educated guesses, and also that there's a lot of iteration involved. And I would just encourage Madam Hearing Examiner that when you get to that point in the development of your proposed rates, that you recall that there is some aspects of this which require iteration, which are not, I expect you'll be specifying a lot of the parameters, but there may be parameters that you don't specify that are material to this. And I would hope that you would keep that in mind. And I would state, I haven't checked with him, but I'm fairly certain my witness, Mr. Bacchus, would be available if there was any interest or need to have him consult and be willing to abide by any confidentiality. And I would just, to make my point very explicitly, that when there are some factors in the rate design which are going to be iterative and based on judgment calls, that unless, if it's all coming from yourself, that would be all well and good. But if any of that's left to the other witnesses, I think it would be appropriate to allow our witness to weigh in on that as well.
Okay, thank you. I will take that under consideration.
And Madam Hearing Examiner, I would also like to offer Mr. Provencio on similar terms if you get into that level of rate design. He addressed certain tariffs in more detail than some other people did.
Thank you. I mean, this gets into a difficult point, which is if I'm going to recommend different rates than EPE has proposed, and there's not a lot of evidence regarding how EPE designed those proposed rates, leaves me in a difficult position. I mean, I don't think I can be asking the members of the committee essentially for oral testimony. So I appreciate what you're offering. And as it comes down to that point, of course, I'll be thinking more about that, and I will be considering what you both just said.
Thank you, Madam Hearing Examiner. And I think I intend to address that in our briefing. And it's our desire that you propose different rates than EPE, and I think what we will do is we'll give you what we think the criteria or specifications are, but the calculations are obviously not going to be possible until you come up with your recommended rate design and class allocations.
Right.
And so I think it's doable, but I do think it is going to be a little bit more subjective, and I'm not requesting testimony, confidential testimony, of course.
Okay.
Madam Hearing Examiner, the city will, in its brief, continue to recommend a phase 2 for rate design, but we'll work on some sort of a proposal to help clarify. We understand your dilemma, it's our dilemma as well, and we'll work on coming up with something that's helpful, we hope, in addition to the request.
Okay, and Ms. Stevens, I don't think there's anything wrong with me giving a heads up about this, but I'm inclined to deny that request for phase 2 because I don't know if I have the authority to do that myself. And frankly, I think the request should have been made in a motion shortly after EPE filed its application. And I think it was probably too late when it was requested through the filing of witness testimony. So I'm just giving you a heads up that you might, given my inclination, if you have recommendations on rate design, you should probably include them in your brief.
I will, thank you. It never occurred to me that a motion early in the case would be appropriate. We thought, putting in the testimony was right. But I understand.
Anything else before we go off the record?
Nothing else, Madam Junior. Thank you for your work on this case.
Thank you all very much. You've been a very pleasant group to work with, and I appreciate you all getting along so well. Oh, one more thing. I have this information for staff But for the EPE witnesses on the committee, for Mark Garrett, and for Andrea Crane and Doug Gigax, I will need email addresses. If they're different from the email addresses on the service list, and cell phone numbers. So if you forget to send those to me, you don't need to send those to the entire email list. You can just send them to me. If you forget, I'll remind you.
Madam Hearing Examiner, may I ask one very practical question? How long is the Dropbox going to be available? Do I need to download everything today? Is really the question there. But do you know?
So I guess I can keep it up until I need, until my next hearing, when people will be filing uploading stuff to Dropbox. And I think my next hearing isn't until April. I don't think they get automatically taken off. But, you know, Mr. Lee will be filing with the transcripts, the exhibits, and they'll be posted on eDocket. So you'll see them there as well.
Mm-hmm. They're easy to get at on the Dropbox. So thank you. I know nothing about any of this. So
okay, so I won't take them down until I have to.
Thank you.
Anything else? Okay, again, thank you all very much. And Mr. Lee, thank you. It's been great working with you.
Thank you, Mr. Lee.
Thank you, Mr. Lee.
Madam Hearing Examiner,
Yes.
on those rules, is that parentheses F, parentheses 1?
Yes.
Thank you.
Okay, thank you.